And I'm going to, I see we have many friends in our little lunchroom here. I am going to start us off. My clock shows that it's 12 noon. And I would like to welcome those of you who have joined us today for our Lunch and Learn, our weekly Lunch and Learn. I am going to remind you all that we are recording, so that my hope is that afterwards we can share this presentation. You can share it with friends and colleagues. You don't have to be too frantic about taking notes. Our speaker today, Arla Cahill, has been kind enough to offer to provide us with some follow-up materials, which are often very, very helpful, and even links. I think, Arla, you said there are some follow-up materials even beyond what is included in today's presentation.
Yes.
So, I also will tell you that we are A-okay with your camera not being on. I understand some of you are working very hard, and this might be the only time you have to sit today and put some nutrients into your body to keep doing what you need to do. So feel free to keep the camera off, to know that we are here. We are having lunch with an expert today, and she is quite an expert. Our topic is understanding basic rights in special education. And Arla is has been practicing law for over 24 years. And she has also just said that from the get-go here, this lunch is for you. If you have a burning question, or if there is something in particular that you're really hoping that she's going to cover today, please type it into the chat. Myself and some of my coworkers are keeping a close eye on that. So Arla, I think, could probably talk for 3 days about what she would like to share with you. Am I right? 3 days, maybe?
I think so, yes.
So she would really like to make sure, if there is a topic in particular that you're really interested in hearing about, please let us know through the chat, and I will let Arla know, and we'll make sure that we cover it. The hour will go quickly, I'm sure. So that's the chat. Use that if you can. We're happy that you're here. And this lunch with Arla Cahill, as I said, she's been practicing law for over 24 years. She is a partner at Mandelbaum Salzburg in Roseland. She chairs that firm's education law practice, and she also co-chairs their special needs practice, and has represented special education for students and families for over 16 years in all aspects of special education and school discipline. And Arla, I like that you say that your experience earlier in your career of representing school districts it brings in a unique understanding of how what some of the barriers might be, and also where some of the missed opportunities to work more closely together fall. So your information, your input today, I think, is going to be very helpful, because I know we have some school officials, I know we have parents, and we were talking before we got started today about the role at Family Partners, which of course I know everyone I hope has heard my story. We're here to help parents who have a child with a challenge, and oftentimes there are so many wonderful services and so many wonderful contacts and providers that sometimes parents don't know, because they're new on the scene, or they're overwhelmed or exhausted or frustrated or whatever it might be. And Family Partners helps those parents connect to the right resources. And Arla, you were telling me this morning about you do these table talks, which I just love the concept, and that where you're trying to help parents understand even the language and the terms, correct, of navigating the system?
Yes, Holly. Special education is such a complicated area, and families are overwhelmed with what they have to deal with on a daily basis with respect to meeting the needs of their child. It's hard to become a mini lawyer at the same time, and at these various events, we reach out to families to educate. That is one of my primary goals, is to get information out there, to educate on terms, procedure. Special education law is very highly procedural and can be complicated and also overwhelming. And lawyers, schools have lawyers representing them, which is fine. But a lot of times parents don't have lawyers representing them. So they have to rely upon their ability to learn learn the ropes and understand concepts in special education, to make sure that they're advocating for the rights of their children. So my job, as I see it, is to reach out to the public and educate, and this is to present that information.
Right. And what I love, a word you used earlier, Arla, was one that we at Family Partners love, which is empower parents.
Yes. Yes.
Empower parents. And also I like that you're You mentioned that you have experience with the school systems because it's not us against them, which I think sometimes it may feel like that for both sides, because oftentimes there's a little bit of a tug of war or a passing of the hot potato as to whose responsibility certain tasks are. So I hope that today, I'm looking forward to, I will stop babbling, but I like that we're trying to bring minds to the table to figure out how we can all work better together. Am I right? To benefit the kids, because that's what we're trying to do. Okay.
Absolutely.
I am
Yes,
going to turn it over to you, Arla.
very good. Thank you, Holly. And I will try to be technically proficient on my end. I have a PowerPoint here that I would like to share with everyone. My goal is to assist parents in working toward a collaboration with their school districts. There's enough stress in the world where you don't want to be having a battle with your district as much as you can avoid it. I mean, sometimes that does happen. But hopefully today I can provide you with an overview of basic rights in special education that'll get individuals who are new to the system more familiar. If you're more experienced in this area because your child is further along in school, there may be additional things I can provide to you. And then basically, we're going to discuss what's happened with the pandemic and how that's impacted school districts and learning. So I'm going to try sharing my screen right now. And Holly, you just help me if I don't get it right.
You've got this. I'm confident you've got that. There we go. So far, so good.
Okay. And let's see. Okay. I think I've got it on right.
Yes,
okay.
Perfect.
All right. So my overview here is a couple major topics, okay? I'm going to go over each of these topics, and then at the end, we're going to talk about learning loss. So the first thing I want to start off with is many of you have probably heard about Section 504 and the Individuals with Disabilities Education Act. Oftentimes, I encounter families and clients who are confused about these two statutes. Both are important, but I'm going to just give you a little overview here about some of the major differences. There are many differences, but this is just a little snapshot for your benefit. So Section 504 is a law, it's a federal law that I like to call like a barrier access law, similar to the Americans with Disabilities Act. Section 504 prohibits discriminatory policies, practices, and physical barriers to places of public accommodation. And a school district, as a public school, is a place of public accommodation. So there has to be equal access to educational facilities and benefits that others, typically developing peers, would also have access to. So I'll give you a couple examples. A student in a wheelchair has to have equal access to the facilities. A student with, let's say, a peanut allergy, that student has to have equal access to the school facilities and education. So various measures have to be taken to accommodate that student to enable them to benefit from their education. The major difference with respect to the 504 and IDEA, which is the Individuals with Disabilities Education Act, is that under 504, there typically is not a written plan, although some schools are now gravitating toward that. There are less procedural safeguards, and if there is a written plan, it doesn't require the parents' consent. The parents are entitled, though, and should be informed by the school district if there is a Section 504 plan, but there's no need to request the parents' consent. By contrast, the IDEA, which is the statute we're going to be talking mostly about today, is highly procedural, contains procedural safeguards to protect families, parents, and their children. Consent is required before implementing the initial IEP, which is an individualized education plan or program. And there are litigation aspects to the IDEA. In fact, we'll talk about that a little later in my presentation concerning mediation and due process. So you get many more protections and procedures to protect families and their children under the IDEA. And if I'm going a little fast, it's just because I'm trying to get everything in, but you're going to get copies of these slides so that you'll have them to refer to for your future use. So when you take a look at how does special education and regular education come together? So you have regular public school education, which essentially is no additional accommodations. It's just simply, it is what it is. 504 is within that, in that it allows access to education and educational services. And then the IDEA gives additional enhancements to eligible students who qualify under the IDEA for special education and related services. So we're going to focus on special education under the IDEA today. And I want to just run through basically what is special education. So it's specially designed instruction that's individually tailored to a student who has been determined as eligible for special education and related services pursuant to the procedures that are set forth under the statute. And I didn't mention it before, but the IDEA is a federal statute. New Jersey has adopted, through implementing regulations, the vast amount of the provisions of the IDEA. So we have the New Jersey Administrative Code that sets forth the special education laws in New Jersey, and in many regards, it mirrors the language of the IDEA. There may be some differences, but for the most part, the concepts are the same. Also, special education in the public school context is free of charge. It is a right. It's a civil right, and it's part of the constitutional mandate for free, appropriate public education, which I'm going to talk about in a few slides from now. And it's also provided in what's called the least restrictive environment, and I'm going to go through what that means as well. So these are terms that families with special education students need to become familiar with so that they can understand what's taking place throughout the course of their child's education. And I think I accidentally went too far back, so I'm just gonna, okay. You know what, I think I went too far ahead. Let's see if I can go back a little bit. Okay. Sorry.
Thank you for doing all the slides. It helps, Arla. This is a lot of material, and I think we all feel a little bit at ease knowing that we're going to be able to have our hands on it afterwards.
I hope to get more technical proficiency as time goes on, but
you're doing a great job,
So let's talk about who's entitled to special education. It's a student or children with disabilities from the age of 3 through age 21, or high school graduation, whichever comes first. That's really important because I find that families that I encounter are not aware. They make an assumption that a child is eligible for education starting at age 5, and that may be true for regular education students, but it differs for students with disabilities, age 3 and onward. Likewise, sometimes families are surprised that education is required to be provided for eligible students through the age of 21. And in many instances, that's very important for the development of self-sufficiency, autonomy, and life skills for students, particularly who are more severely disabled. So as I mentioned before, federal New Jersey law work together and require that public schools deliver a free, appropriate public education, which is called FAPE, and within the least restrictive environment, which is short term for that is the LRE. So FAPE refers to the educational program and services that are individualized for a specific student and meet the standards that are established by the public or established by the organization and provided free of charge. And FAPE is very important because that's going to be key to the legal standard at a later point should the family and the school district have a disagreement. The typical disagreement is that there's a failure of FAPE being provided by the school district. So when controversies arise, that is the typical claim. What's really key here is that with special education, it's individually tailored, unlike with regular education, which is more like a one-size-fits-all presentation. The student who is entitled to special education must have that education individually tailored to meet their individualized needs. And I'm going to explain to you how those needs are determined. Now, the least restrictive environment is another key term that's important to understand. And it's often misunderstood by not only families, but also school districts. And when I, back in the day, very early on in my career, I represented school districts. I gave in-service training to our school clients to explain to them, it seems like semantics, but it's actually very important. So the LRE means that to the maximum extent appropriate, school districts must educate students with disabilities in the regular classroom with appropriate aids and supports, along with their non-disabled peers in the school they would attend if they were not disabled, unless, of course, the student's IEP requires some other arrangement. It's really important to understand what LRE means because I have encountered situations where districts believe that regardless of the disability and how disabling the condition is, they misunderstand and think that they must retrofit the child into a regular education classroom to the extent where that child, because it's not an appropriate environment, is very disruptive to the regular education students. It doesn't necessarily mean that. Although that's the goal of the IDEA is to, you've heard the word mainstream, as much as possible, it doesn't mean to the detriment of both the child who's special needs and to the detriment of the regular education students. So it's a delicate balance. It can be somewhat controversial for some.
You should cut down on your thinking. Have you ever been angry or annoyed by something someone said? Have you felt guilty?
Okay, not. Okay.
Arla, I think we had you muted inadvertently. Are you there?
I'm here. Okay. I saw my mouth moving, but
that's the excitement for the day, folks. I hope that's as crazy as it gets. I'm sorry, Arla.
okay. No problem. All right. So I'm just going to get back to my slide because in all that tapping around, I think I got out of the mode here. So bear with me a second.
It's not a presentation unless we have a little excitement. It's a presentation then.
Okay, there we go. Okay, so let's start off with the basics then. How do we find out if a student is appropriate for special education? And it starts with a referral. A referral is a written request that will go to the school district that says that there's a basis for an evaluation because there are suspected areas of disability. And for some students, depending on the type of disabling condition, this might show up very early on in the developmental phase of their infancy, particularly like, for example, autism, that may show up around the age of 2 to 3 years old. There's a mandate called the Child Find Mandate. So pediatricians are required to be on the lookout for students who may have disabling conditions. So, and then school districts also have a Child Find Mandate where they are supposed to identify and locate students who have a disabling condition and evaluate those students and determine if they are eligible for special education and related services. So referrals can come from parents, school personnel, and also agencies that are concerned with the welfare of students. So this could also include the New Jersey Department of Education. So the parent who has an inkling that there may be something awry with the student's development, there may be some disabling condition, they're not really sure, what do? Well, they have to put in writing. It's very clear under the IDA, and it's very important that a request to the school district be in writing requesting an evaluation. And that typically will go to, I often, on behalf of parents, will write those letters directly to the director of special education. If there's been a case manager involved, write to the case manager, but you want to make sure it's in writing. And that has to go to the school district in which the student resides, or where the student's attending school. So when it comes to a child who's maybe 3 years old, you have to enroll the child in school, make the request, and the district will be obligated to hold a meeting. So we're going to talk about what happens. So after making that request, the district has 20 calendar days from receiving the referral to hold a meeting to decide a couple of things. One, whether or not an evaluation will be conducted, the types of testing and other procedures that are going to be undertaken in furtherance of the evaluation. If an evaluation is not going to be conducted, the school district has to advise the parent why, what the rationale is for that. And there may be situations where the student may not qualify for an evaluation, but the parent is given a referral with respect to other interventions or services. And I also want to point out the 20-day time frame, another area of confusion. It's 12 months a year except for holidays, okay? So New Year's Day, not good, but every other day except for holidays is that 20-day period covers that. Now, a couple things, and again, this is often a frequent misunderstanding, I would have to say. In some districts, again, this is not necessarily anyone trying to withhold services, but there may be times where a parent is informed that there's a wait list. There can't be a wait list. It has to be done. As I mentioned, there's no such thing as, you're too late. Sorry, you got to wait until September. I often encounter that in June or July of summers. And then, I realize, that there are certain staff shortages during the summer, but the school district has to make those arrangements to have students evaluated. It just has to happen. The child is also not obligated to try other things. Like, for example, another common situation that comes to me is a student who's having speech difficulties, and there's a suggestion by the district, why don't you try some speech therapy on your own first? That's really not appropriate. So a parent has to be firm in their request, and it has to happen. And I'll explain later in my presentation, if there is a dispute that can't be resolved informally, it may have to go to due process or mediation. So the initial evaluation is what's going to be the means by which a student is evaluated and determine what the limitations of the student are, and what services or program needs that student may have a need for. So the initial evaluation has to have at least two, I say CST, it stands for Child Study Team members, and other specialists. Could be a neurologist or a speech therapist. There also has to be a minimum of 2 assessments of the child to determine the eligibility. And each assessment, I think it goes without saying, has to be done by someone who's qualified and has the appropriate training to perform that assessment. And an example would be, like, for example, a student with autism, you need to have a neurologist, an MD, do that assessment. You can't have, let's say, a social worker do that assessment because it requires a medical diagnosis. So we want to make sure that families are going understand that they have to go to the correct professional. And that professional, of course, is selected by the district. You have to give the district the opportunity to use professionals that are either employed by the district or contracted with the district to perform those assessments in connection with the evaluation. A lot of times families are beholden to a particular, feel very comfortable with a particular professional, and they want their professional to perform the evaluation. It's really not possible all the time. There may be a circumstance where a district might consider it if it's a particularly unique profession. But in most circumstances, the district already has set up their own professionals to conduct these evaluations. That's their expertise. They're in the business of education, and it's their job to have the appropriate professionals at their disposal to conduct these evaluations. So the scope of the evaluation has to be an assessment of all areas of suspected disability. So a student may have fine and gross motor skill impairments. They may have perhaps some other issues, maybe emotional disturbance, whatever those areas are, speech delays, those areas each have to be assessed by the appropriate professional that understands those particular disabling conditions. The school district pays for the evaluations. The school district is not permitted to tell the parent they have to go get the evaluations on their own at their own cost. It has to be at the public cost. The child study team can also consider evaluations that were obtained privately by the parents. And that's very common. Parents on their own will obtain, let's say, a neurology report, and they bring that to the attention of the district as part of the referral process. A district can certainly consider that and use that among other assessments to evaluate the needs of the child. The time frame that the district has from the point of the parents signed consent for the evaluation is 90 days, and 3 things have to occur: the evaluation, a determination of the student's eligibility, and the development and implementation of an IEP. Having dealt with districts for many years, sometimes it gets hard to meet that time frame, and districts may they may go over the 90 days. It's really important that a parent stay on top of the timing. You really want to hold the district's feet to the fire to get that evaluation and the IEP and eligibility determined so that the student is not losing out on educational benefit for a potential program. The eligibility determination meeting is the meeting that occurs after the evaluations have been performed. The parent gets those written reports at least 10 days prior to the eligibility determination meeting. And that's important because the parent needs to review that report, understand as best as they can what it's saying, so that they can come to the meeting with the school's professionals and discuss it. I have had situations where families got the reports like the day of the meeting. It's really not appropriate. So a parent, again, this is a reason why the parent should understand what the timeframes are. There are a lot of numbers involved with special education, 10 days for this, 15 days for that. It's very hard to keep it all straight. I hope this presentation, when you have it in hard copy format, will help you keep track of those various deadlines. So the requirements for eligibility determination requires 3 things. The student must have a disability according to one of the eligibility categories, and I'm going to show you a list of those in the next slide. The state of New Jersey's administrative code sets forth 14 categories. The student has to be evaluated by a professional who determines that the student meets the criteria for one of those 14 disabling conditions. The disability must adversely affect the student's educational performance. So notwithstanding the disability, if the student's educational performance is not impacted in any negative way, then there may be a finding that the student's not eligible for special education. Most times, though, the disabling condition does, in fact, impair educational benefit and the ability to learn. And the student must be in need of special education and related services. So commonly with autism, a student will be in need of occupational therapy, speech therapy, other specialized instruction. So that student would be eligible. So these are the 14 eligibility categories that are set forth in the New Jersey Administrative Code. You can Google them online and you'll get more detailed information about how each of these conditions are evaluated and what criteria must be met in order to actually qualify under those particular categories. The most common ones that we see, autism, intellectually disabled, communication impaired, emotionally disturbed, multiply disabled, and other health impaired, and preschool disability tend to be the most frequently observed eligibility categories, at least in my experience. So the determination of eligibility at the meeting, you're going to have the participants will be the parents, of course. The purpose is to review the reports, have the professionals from the school discuss their observations, decide if the student's going to be classified, and if eligible, typically what happens is the school will immediately move into an IEP meeting. So they kind of happen back to back. There are situations where the evaluations are conducted, but the school determines that based on the outcome of the testing and evaluations that the student does not qualify, meet that criteria for eligibility for special education. In that case, the school has to provide written notice and the reasons for the denial. And as mentioned in my slide here, parents can file due process or mediation to challenge that if they believe that that's an incorrect determination. A lot of times students have certain delays that don't rise to the level of a disabling condition under the 14 categories, but they may have some impairments that require intervention, and schools will offer intervention, but just short of an IEP. And that's the intervention and referral services. So in kindergarten and beyond, the districts must offer the IRNS program to the students who have some either learning, behavioral, or health issues in the school, but do not qualify for eligibility for special education. So the preparation of the IEP, this is the individualized education program that once the student's eligible, then they get an IEP. The IEP is like a contract. If it's not in the IEP, the school district isn't mandated to provide services. So you want to make sure as a parent that the IEP it will contain the unique and individualized educational components that were identified in the evaluation. So let's say the speech evaluation indicated that the student needs speech therapy, and maybe it may say that the student will benefit from either individual or group therapy. Well, the IEP should provide for speech therapy and specify whether it's individual, whether it's group, it might be both. It should say the duration, the number of times per week, etc. So it's a written agreement, very much like a contract. What's in it is what the school district is bound to follow, okay? And it's going to identify all services that the student is entitled to for that particular school year. As we mentioned early on in the presentation, the goal is to have a collaborative approach. That is the goal of the IDEA. It's really the most efficient way to do things is to have a collaboration. So the IEP team is going to consist of the parent, sometimes the student, depending on the age of the student, usually a much older student, a case manager. This will be the lead person who is in charge for managing the student's special education. One of the student's regular education teachers, or if there isn't one that's specifically assigned to this student, one who is knowledgeable about the school's program. You're going to have a special education teacher and other school staff as appropriate. So for example, a student who is recommended to receive OT, occupational therapy or speech therapy, you should have that professional at the meeting, because that person's input is going to be important to determine the services necessary, the frequency and duration of those services for that student. The parent also can bring individuals to the meeting. You can bring a relative, a friend, anyone who you think is going to help you get through that process. Perhaps a lot of parents will retain an educational consultant because they need someone with specialized expertise to help them interpret some of what's going on in the meeting, and also to understand the nature of the services being presented or recommended by the school district.
Arla, can I interrupt with a quick question?
Sure.
Would the state, it's a question from one of our participants, would the state fund this child if the parents identified the child needed help before kindergarten?
If I understand your question correctly, so if the student needs services prior to kindergarten, will there be funding? Is that your question?
Yeah, or perhaps they're evaluated privately before kindergarten, like if they're trying to maybe be, on top of it. How would that affect, or is that very unusual for that to happen?
Not unusual at all. Students who have disabling conditions are eligible for special education from age 3 to 21. So parents can certainly get those evaluations on their own, but you're a taxpayer, so you should contact your school district if you believe that your child has a disabling condition. You don't have to, you're not under any obligation to diagnose your own child, but if you see learning delays that cause you concern, write a letter to the Director of Special Services of your school district and request referral for evaluation. And
okay, that's helpful. And are there consultants on this kind of thing? I'm sure there are. I'm thinking obviously the work that you do is somewhat of that expertise, but what are good resources for parents to go to for assistance in even going through the process?
There are educational consultants who provide services on a private pay basis. There are various programs that are state funded for individuals with certain income limitations. There are advocates who are specially trained individuals that assist parents. They're non-attorney advocates who many times either it's a parent who went through the system already and has developed a level of expertise and know-how. It may be a social worker who feels that this is something they want to do. So there are avenues in which the parent can find individuals, short of hiring an attorney, who have this specialized knowledge or at least understand the system and how to guide the parent in getting connected with resources. But the main thing for a parent of a young child where there's a suspected disability, the parent has to reach out to the school, because as soon as possible, you want to have those evaluations conducted, not wait, long. Now, of course, if parents want to utilize their own private insurance to have evaluations done, they absolutely can do that. There's certainly no prohibition. School districts will consider those evaluations. It's without prejudice to their ability to seek publicly funded education.
Okay, thanks. And New Jersey SPAN, that's another group that maybe could be helpful to parents navigating.
Absolutely. There's Autism New Jersey, which is a wonderful resource. SPAN. I am a member of the Council of Parent Attorneys and Advocates. A lot of different organizations out there, so many different organizations. Really just doing a Google search can bring up a lot of organizations, and a parent will have to just sift through each one to see what's the best fit. It's a personality of the organization fitting with the family's needs. You know, certainly one of the finest organizations with respect to autism is the Autism New Jersey. I think they're an excellent resource for families dealing with autistic students.
Perfect, thank you.
So I'm not sure how we're doing on time, but I'm gonna.
It's 20 before. We have 20 minutes left, and I just had a COVID-19 question come up, so I'm gonna throw it at you, Arla. This is where it becomes fun. You get to dance around.
Sure.
We have a participant who asked, due to COVID-19, what should the school do to provide reevaluations?
Yeah, excellent question. And I was prepared for that question today because this is a time where special education students, unfortunately, are not getting what they're entitled to. And it's not necessarily the fault of the district. It's just because our hands are tied with the restraints. So concerning, you know, the executive order, you know, the stay put, which obviously was lifted just a few days ago. But right from the get-go, starting in March, the State Department of Education and the U.S. Department of Education made it very clear in various written guidance, which is in my materials that everyone will receive, stressed very unequivocally that districts are still required to provide a free appropriate public education and to the maximum extent appropriate, provide the special education student with their special education services and related services. And in fact, the State Board of Education did an emergency amendment, temporary emergency amendment of the New Jersey Administrative Code, allowing school districts to provide related services using telehealth, telemedicine, and remote means, which in not all circumstances, not all types of services, it's really practical, but the objective was to give as much flexibility as possible to school districts in order to get services to students. Now, of course, there are many types of services and students, it's all individual, who just can't benefit from a remote delivery of services. And I'm going to kind of go off the script, and I'll just go more into what I was going to talk about at the end of the presentation since we're running short on time. What's been discussed in written publications by the Commissioner of Education, the Department of Education's written guidance, and this is all on the Department of Ed website, but I'm going to provide copies to the participants today. Students, it's been indicated by the Commissioner that schools will have to start now evaluating what compensatory services the school districts will need to provide to students once we get back to normal and school districts are open. So it's already a conversation, and it's already in writing that school districts are going to have to provide compensatory education. And what that means is there's a recognition that there's going to be learning loss as a result of the COVID-19 pandemic shutdown and the closure of schools. It's just inevitable because students, even regular education students, are not getting the delivery of educational services that they're entitled to just because of the circumstances. And the compensatory education is a concept where you typically in litigation context, again, pre-pandemic, compensatory education was an equitable remedy to provide a student who was being denied FAPE with additional educational services to assist that student in regaining or gaining the lost educational benefit that they should have gotten in the normal course during their program. So I think we're going to see a lot of those situations. I think parents right now need to start documenting areas where their child has experienced a regression and a learning loss, some of which can be, pretty obvious. Others are probably much more subtle. And have a dialogue. Start now speaking with the case manager. Start speaking with the teacher. These conversations should have already been occurring because school districts were greatly encouraged by the New Jersey Department of Education written guidance to reach out to their parents and to start speaking. So back in March when this all happened and continuing after that, hopefully districts have taken special attention to keep that communication live with their families that they're serving. And I know that there are circumstances, unfortunately, where districts have not reached out to their special education students through their parents, and they got a generic packet. That's not acceptable. And of course, families really need to reach out to their school districts and demand more and find out, how are you addressing, what remote services are you providing that are specifically tailored to your child. And the packets that went home might have been fine for a regular education student, but in a lot of instances, it's not going to be appropriate for a special education student. So again, depending on the nature of the student's disability.
What I'm going to paraphrase for you, Arla, just so that to make sure I'm understanding, is that I'm sure these conversations might be hard for parents to follow up with to begin with. There's a lot of hurdles, a lot of hoops they need to jump through normally.
Yes.
But what I'm hearing you say is that it's worth really pushing through these conversations, because the schools are still under obligation to not only continue the services the child's entitled to, but also to help make up. Because I'm looking at some of the comments where like when they're missing OT and speech, or PT, it's like there's some frustration. I have another participant who said, I have a 7-year-old male with ASD and ADHD, and the parents are defeated and frustrated, as far as trying to find and connect to the right resources. I'm hearing you encouraging them to reach out to the school. This is not a time to be shy or to be apologetic. This is something that is due. It's difficult because, of course, the schools they're learning as we're learning, right? I mean, I think it's the important thing is to try to figure out how we can work well together in moving forward, and for each child and each school. It's going to be a different process, a different story, really.
It's hard. It's easy for me as an advocate to tell you to go advocate for yourself. And I truly appreciate that there's a level of discomfort in a parent reaching out to the district. I would say you don't need to do it in a combative fashion, but you need to ask. The squeaky wheel gets the grease, as I always say to clients, and you need to reach out to your districts, your case manager. And I would recommend that, first of all, IEP meetings are occurring. They're occurring remotely. So if you haven't had your IEP meeting, or if you had it, but now you're concerned that you're not sure what's going to happen for September, and you have additional concerns about learning loss, I would ask in writing to reconvene another IEP meeting and request extended school year services in the event that those are not already part of the IEP. The extended school year, if that's a concept that is new to you, anyone listening, is it's a concept that addresses learning regression for students who have a disability where that 2.5 month period away from school would cause learning loss and learning regression. Well, we're in a situation that's unique, but there's going to be, and there is, learning loss. And an extended school year would at least help mitigate against some of this learning loss and regression that has been experienced in the last 3 months. It's almost like we had summer vacation early this year, and then to have another 2 to 2.5 months of summer vacation, that's like 5.5 months of really not getting a full education. So I would encourage parents to ask for extended school year services, ask about what remote learning services that can be provided to their child. Of course, I recognize some children cannot tolerate that. It's very hard. Again, we have to be a little bit flexible, but at the same time, we need to keep pushing. We need to be firm. And it doesn't stop with the end of summer. So let's say you have extended school year, but you still have issues with regression and learning loss. You need to keep pushing. How are we going to make up the speech therapy? How are we going to make up the OT? Those services need to be increased, and that request has to be made to the school district to increase those services. I think we're really gonna see some unprecedented situations, probably starting in September, October this year, where it's gonna become very obvious that the last 3 months have just had a real devastating effect on learning, particularly with special education students. So does that answer your?
I think my questions in the chat box have ceased at least now. What's the biggest thing that you would advise parents and even schools in moving forward? I mean, you have a very unique position in this scenario. You've seen, as you said, from the educator's point of view and from the parents and the student learning. You know, what's your biggest piece of advice that you wish people had in their heads and had in their ability to do or to keep in mind?
Okay, well, a couple of things. One, there are an enormous number of resources out there. So looking beyond the school district, your school district likely has limitations in that they, like everyone else, everything's shut down with a moment's notice. There are a lot of free resources on the internet that have been developed by various nonprofit educational organizations that may be helpful to assist you. I would see the summer as not a vacation, but as an opportunity to double down on learning skills, reinforcing previously learned skills, adding to the educational component. I think although the school district has been told by the departments of education, state and federal, that they have to provide, you know, the special education services, the reality is it likely has not occurred in a way that was beneficial. And the parent will have to rely upon additional resources that may be available in the community, may be available online. And then a second part of that would be, you know, I think like a litigator, because I've been litigating for my whole career, I would keep track of the number of therapy sessions that have been missed during this school year. Keep track of that. Keep track of what instruction has been missed. You know, for example, if the student was getting home instruction but hours were missed, even if we were not in a pandemic situation, I recommend to clients, keep a record of that, because you know what, unfortunately, it may be that if you can't work it out informally with the district to recover those services and have that compensatory education given to you, you may have to pursue mediation and/or due process to get an order from the Office of Administrative Law to compel the district to provide those services. I haven't talked about the litigation, but I can try to skip ahead real quick. I'm just gonna run through some of these things we have already talked about. So I'm just gonna, here we go. Disputes with the school district. The relationship between the school district and the parent is a long one. So particularly if your child is you know, 3, 4, 5, 6 years old, it's going to be a long relationship if you reside in that district. However, there comes a time when it cannot be worked out and you may have to file for mediation or due process. And these are part of the procedural safeguards of the IDEA. And if you go onto the Department of Education website, they actually have forms so parents can actually represent themselves. My recommendation is you generally don't want to represent yourself. You would likely want to have either an attorney or an advocate assist you, because there's an art to litigation, and not all of us are you know, trained in that. It gives you an advantage. But if you had to represent yourself, there are some very good materials on the Department of Education website that help walk you through what you need to file. So with a mediation or due process, there's an application for that on the website. And I also wanted to point out, let me see a couple of different things. one of the things I just wanted to bring up, which is it's important because I think it's an issue that I think parents are not aware of. After the implementation of the initial IEP, if there is a change that the district wants to make to the IEP following the implementation of the initial IEP, the district can go ahead and do it, and it doesn't need the parents' consent. So I think that's something that's very important for parents to understand, because there's a very limited time frame in which parents can pursue and enforce their rights. So let's say the district, which has to give written notice of that proposed change to an IEP, and the parent disagrees with that, the parent has to file for either mediation or due process within 15 calendar days from receiving notice, written notice of the proposed change in the IEP. The reason why that's important is, let's say you like the program and placement you have right now, but the district wants to take away one of the sessions of occupational therapy, and instead of 3 times a week, they want to do 2 times a week because they've decided that OT, the student's doing well and doesn't need as much OT. You disagree with that. Well, the minute you file your request for mediation or due process within that 15-day calendar day window, a doctrine called stay put happens. And that, by operation of law, stay put freezes the program as is. So no changes can be made by the district during the quote stay put until there's a disposition of the mediation or due process petition. So I want to encourage families to take a look at that part of my materials. It's very important because you lose the advantage of the stay put if you don't file within the 15-day period. Okay. Were there any other questions?
Yeah, I'm looking, Arla. Someone is asking, would private insurance cover services privately if the school is not available to under the present circumstances? Is that an avenue you would recommend exploring?
A parent can consent to have their insurance company pay for evaluation, but a school district cannot say you must use your insurance to pay for an evaluation. So at the first instance, the school district has to pay a public expense. I have a list of questions that sort of Q&As at the end of my presentation here, and that one of those questions is whether or not evaluations are still occurring during these times. And the answer is yes, to a certain extent. Certain evaluations can take place remotely. Certain physician offices are now reopening under certain restrictions. So if the concern of the individual who posed that question is, and I can't see the questions on my end, so I'm kind of imagining what the purpose is, but if a school district has said, look, sorry, we can't do it, you have to go on your own to your insurance company, that's really not an appropriate response by the district. The district has to provide that evaluation at its cost. So I'm not sure exactly what evaluation may be at issue in this particular instance, but they are occurring. It's just some of them cannot occur the same way because, for example, if there's an assessment like a play-based assessment,
right? Or even, I guess, missed therapies. Do you know what I'm saying? If the school is unable to do it, could a parent pursue it privately through their insurance? I'm sure it would really depend on the insurance, I would imagine.
It would depend on the insurance. And I think the parent who may choose to do that, and that's fine. That's not going to absolve the school district from providing what they agree to and are required to provide. So a parent most certainly can supplement their child's therapies by pursuing private therapies, whether it's either private pay or it's through insurance compensation. That's fine. It's not going to.
But could they submit to the school that I've done this in the absence of your being able to provide it? Is there any kind of compensation for their out-of-pocket expense? I imagine that gets quite complicated.
It does. I would say that the school district will likely say no, but I wouldn't, I would first approach the school district. I would contact the director of special services and say, look, you're not paying for my OT. I can get the OT through a provider. Will the school district provide that? Now, I want to give you a caveat though, because when a school district does something that's kind of out of the norm like this, they may want you to sign a waiver. And I caution parents against signing any kind of waiver. You're entitled to what you're entitled to. So the fact that you've had to exercise in extraordinary measures to get services for your child under these extreme circumstances should not cause the school to compel you to sign a waiver. Most times, in my experience, a waiver is very broad, and it basically will absolve the school district of any responsibility for providing educational services. So be cautious. I certainly think it's worth trying to ask to see if the school district will pay. You want to get it in writing that they will pay you and compensate you if you have any out-of-pocket expenses. But you want to set that up ahead of time. You want to have it in writing, and you don't want to sign a waiver. So you need to be careful about that. You may want to consult with an attorney to review any kind of written documentation that memorializes an agreement like that. But it's possible. I mean, reasonable minds can agree sometimes. So.
Okay, Arla, and I've got to tell you, I'm having people say, we've got to have you back. This is too good of information and too much in too short amount of time. So let me just ask you, there was one question I didn't pass along to you yet, and that was just having to do with teachers and, some of these special education students, their ability to meet the COVID-19 standards. Like when we do get back into the classroom, there are certain things that may be required, for instance, face masks or what have you, that might be more difficult physically for some of these students to abide by. Do you have anything to say on that, as far as, I think we're kind of learning as we go, but I see some of this population might be more challenged than others in trying to abide by, or trying to even decide on what's realistic moving forward. Do you have any thoughts on that?
I have some thoughts. I'm not sure if anyone, position of authority will abide by them, but
might be a whole other meeting.
Right now, I've been following this very carefully and closely to determine what the Department of Education is. Holly, I'm sorry. I think I'm having a little communication issue here. Are you able to hear me?
I think it might be. I am able to hear you. I'm going to ask to text in the chat. I think it might be on my end. So feel free to answer. Okay.
The Department of Education, to my knowledge, has not yet issued guidelines with respect to what's supposed to happen come September. I'm aware that some school districts are actually having a remote opening in September. And that's not widespread throughout New Jersey at this point. As far as face masks go, what I've learned to date is that it's more than likely that teachers and students will be required to wear face masks. But with regard to the special education students who cannot tolerate, there's sensory stimulation issues and other issues that prevent a student from being able to wear a mask. I have not seen any guidance at this point that would address this very important issue. At this point, I think, if I were to imagine a situation where a student is in their classroom and they cannot tolerate a mask, certainly there has to be other precautions taken to protect that student's health, so that the instructor, the aide, and anyone else in that class would have to wear a mask. There would have to be, significant sanitation of the room. But I think right now, educators are still stuck at how are we going to maintain social distance regardless. It's almost impossible in a school setting. And, you know, honestly, it's just difficult to fathom. I mentioned to you earlier today, my husband's a teacher, and they are sitting there with bated breath, trying to figure out what's going to happen and how in the world could we possibly maintain the health and safety of students and teachers. It's unknown, but in any event, there has to be some measures taken to address specifically the needs of students who have these difficulties with inability to wear a mask. I don't see how that's going to be possible for certain students. And so I think there are going to have to be additional measures to protect their health.
Well, Arla, I cannot thank you enough for having lunch with us today, for putting forth so many important pieces of information and your thoughts and your advice on this very important topic. And I will remind our attendees that we will be following up with the video of this presentation with Arla's slides, and it sounds like she's going to put a couple extra goodies in there for you that will be helpful resources. And we just want to remind you, you know, Family Partners is also here. We have a warm line that folks can call, that if you are needing assistance, reinforcements, advice, maybe trying to connect with one of these organizations that might provide you with information, but also just, you know, somebody to walk with you in figuring out this new world. You know, the schools are learning as we are learning, and we all have, hopefully, the child in mind. That's the priority of how to best do what we need to do. So, you know, reach out to Family Partners, ask friends, reach out to your school, and, you know, just remember, we're in this together. I love the saying, we're all in the same storm, but in different boats. And we just need to help each other through this. And I know there are many good providers and good guidance counselors and educators out there. We're just trying to figure it out. So Arla, thank you so much for your time.
My pleasure. Thank you.
Remember that your friends at Family Partners are here for you. We have 4 adult support groups a week online. We have 2 for youth age 13 to 21, and our phone, you can still ring us, you can still email us. So reach out, and everyone stay healthy. Arla, thanks 1,000. And you did gold stars on your technical adventure there. I think you did great.
Thank you, Holly. Appreciate it. It's been my pleasure.
Thanks. Everyone take care. We hope to see you next week. We're talking about, actually, we have a speaker for Norwest Cap who will be addressing how to approach or how to tackle when a student is lagging behind in their learning. So we hope to see you there. Take care, everyone.
Bye-bye.
Bye-bye.